Okay, hello everyone. I'm Sacha Wilson. I'm a lawyer. I do a lot of work in advertising, digital and privacy, or privacy if you're that way inclined. Okay, so I've been tasked with talking to you about GDPR and ePrivacy being an opportunity as opposed to, I suppose, a threat. And you hear a lot of people talk about GDPR as an opportunity and don't think about the risks and so on. So I thought I would give you, from a lawyer's perspective, what does that mean? Well, the GDPR is very long and very complicated. There's a lot of stuff in it, but I've singled out a couple of themes that I think are particularly relevant. That is notice, consent, which leads to trust. Now, if you take the first one, notice. So because I'm a lawyer, I spend a lot of time reading the actual law. I won't read out the law for you, but I thought it might be helpful to see what it actually says in the GDPR. And by notice, I'm talking about what you need to tell people about how you use their personal information. That type of thing, transparency, is a fundamental part of data privacy regulation. So up there on the left, that's what's required under the current law in Europe. So the current 1995 Data Protection Directive. In the UK, that's implemented as the Data Protection Act. So that's what you have to tell people about how you use their personal information. That's what needs to go in your privacy policy, your privacy notice. So as you can see, it's not actually that long. It's a lot of stuff that you might think is common sense. Who are you? What information are you collecting? What do you do with it? Now, the stuff on right, in particular the stuff in red, that's what the GDPR adds. So as you can see, the box on the right is much bigger than the box on the left because there is a lot more stuff that has to go in your privacy policy. Some of those things that have to go in there are quite complex and quite nebulous from a legal perspective. You have to talk about the legal basis for processing. You have to talk about your legitimate interests and things like that. That's quite difficult. Now, if you add to that the requirements in Article 12 of the GDPR that all of this stuff has to be concise, it has to be intelligible, it has to be made accessible to consumers, it's very, very difficult to communicate that information in a way that's consumer friendly. A lot of lawyers are struggling to understand what on earth that means. Getting consumers to understand it is even more difficult. So as a result of that, in order to make that accessible to consumers, we have to think a bit more creatively as to how we're going to communicate that information. So you'll hear people talk of the example of, say, Channel 4 getting Alan Carr to read out their privacy policy. I put up an example from The Guardian. They've also done an animation. That's very much the future of communicating this type of information. There really does have to be a closer conversation between the legal teams and the marketing teams and compliance and user experience, because we're very much moving away from a world of long-form privacy policies being stuck in the back end somewhere to a world of a much more interactive user experience where this type of information is communicated to people in a much more creative way. So linked to notice, we have the concept of consent. Now, just before I go into this, it's very much not the case that the GDPR says you have to get consent in all cases. In fact, the GDPR isn't different to the current law. There are various other, what we refer to as legal bases on which you can use people's personal information. There are some situations where you do need to get people's consent, but it's generally under a different piece of law, the ePrivacy Directive, which refers to specific situations where you need to get people's consent. What the GDPR does say is, if you do need to get people's consent, this is how you need to get it. And what consent means is defined in the GDPR. But it's also defined under the current law. So up there, I've put the definition of consent under the current law, so the current 95 directive, as amended by the GDPR. So the stuff in blue is what the GDPR adds. Now again, you can see it's not actually that different to what the current position is. The current law already requires consent to be specific. Someone has to be informed. There has to be some sort of indication by which they're telling you or showing you that they consent. There is a reference to unambiguous that the GDPR adds, but that's actually already in the current law. It's just in a different place in the directive. So if people tell you that the GDPR fundamentally alters what consent means, that's actually a bit misleading. What the GDPR does do is add some hurdles about getting consent in a valid way. So in Article 7 of the GDPR, there are some conditions. So what do you need to do to make sure consent is valid? Well, you have to be able to demonstrate that you've got consent from your consumers. Consent has to be distinguishable, so it can't be buried in the back end of very long terms and conditions or a privacy policy. It has to be easily accessible, so if there's a tick box or something like that, someone has to be able to see where that is, and it has to be really clear what they're consenting to. It has to be clear and plain, and someone has to be able to withdraw their consent at any time. So much like with notice, it's a very similar concept with consent. You have to have a very open, transparent, interactive relationship with the consumers under which they give consent. Now that is particularly challenging in a connected TV environment with a remote control and a screen that's quite far away. So I've put up an example there, a little bit old, but that type of model needs to, again, be thought about quite creatively in the future. How are we going to get consent from people? But again, I should stress, you don't necessarily always need consent, and I'll come on to that in the context of the ePrivacy regulation. So one of the things probably that's most misunderstood is this relationship between the GDPR and ePrivacy. So we have an ePrivacy directive that's implemented in the UK under the Privacy and Electronic Communications Regulations, or PECA as people like calling it. PECA is going to get replaced by a new law, the ePrivacy regulation, in the same way that the GDPR will replace the Data Protection Directive. And the goal of the ePrivacy regulation is to standardize those specific parts of law across Europe. So just before I come on to that, I put kind of two strands, the GDPR and the ePrivacy, and what they mean for the data that you've got. So the first point to note is when the GDPR applies from 25th of May this year, there's no transitional period, and it doesn't apply to data going forward. All data, all of your first-party data that you have on your platform is automatically brought within scope. All of the various governance requirements around the GDPR will apply. Now, something that's got people very excited and scared is the concept of profiling. You hear talk of profiling a lot under the GDPR. That's partly because there's no definition of profiling under the current law, so they've put one into the GDPR. But actually, it's a bit of a red herring. What profiling basically means is segmentation. If you're looking at data and drawing inferences or predicting what people's interests might be or analyzing data. So analytics is another example. That's basically profiling. But you can still do that under the GDPR. It's not prohibited. The area where things get very challenging from a compliance perspective is if you're doing that type of thing in a way which might legally affect someone. The whole point of that bit of the legislation was effectively if someone's applying for a mortgage online, they might get automatically denied, or if someone's CV's getting screened automatically, they might be denied a job opportunity. However, you could theoretically apply that to online behavioral advertising where, for example, someone with a gambling problem might be repeatedly targeted with gambling adverts. And that's something that the regulators were quite sensitive in some of the early versions of their drafting, but they've kind of stepped back a bit from that position. So it's most likely that it won't be particularly sensitive in the targeted advertising world. So moving from the GDPR onto, excuse me, ePrivacy. Now the ePrivacy regulation, as I said, that's a very specific piece of legislation. For the purposes of the people in this room, that applies to email marketing, or what people refer to as cookies, but it's actually much broader than cookies. If you take any data off a device, whether it's a TV, an iPad, or a mobile, if you're taking anything off the device, then the ePrivacy requirements apply. So that includes if you're taking IP addresses or any other unique ID from a connected TV, for example, the ePrivacy regulation applies. And what it basically does is impose a consent requirement. So for those situations, you have to get someone's consent. Now, there are various exceptions. So if, for example, you need to collect that data in order to be able to offer a service. So if you have a recommendations engine, for example, you cannot provide that service unless you collect some data from the device. So in that type of situation, there's an argument that you don't need consent. However, they're quite limited, the consent exceptions. And what they don't allow currently is an argument that, well, in order to provide my service, I have to target people for advertising purposes. I have to track them. Otherwise, I can't provide my service. So it's necessary. The regulators hate that argument and they say, no, it's not. You can only say things are necessary if you cannot provide the service technically without taking the data. Now that argument is under significant debate in Europe at the moment. It's being heavily lobbied, and part of that is what's informing the new ePrivacy regulation. There are a lot of discussions around that in Europe at the moment, and they're potentially discussing more exceptions to that consent requirement. The other thing they're discussing in Europe is how do you actually get consent when you need it? They're mainly obsessed with online, and there isn't a lot of thought of other use cases like connected TV, for example. But one of the things the regulators are talking about is all of those cookie banners that you see all the time. Everyone hates them, no one understands what they're for, and they're a total waste of time. So what happens if, for example, we got rid of them and escalated consent up to the browser level? So it's the browsers who are in charge of getting consent for all the different websites. So you can imagine if you're a publisher, that's a bit problematic because all of that control goes up to the browsers. So again, that's something that's been discussed significantly at Europe. What they haven't done is thought about how that would apply in other situations like connected TV, for example. So there's a bit of a grey area, and it's very much one to watch in this space. Thank you very much.
Thanks a lot. I think that's very complicated stuff, but extremely relevant for everybody in the room. So probably the quickest question is the presentation shareable?
Oh yeah, absolutely. Yeah, happy to share afterwards.
Good.
Yep.
Good. Just to get it out of the way. Any specific GDPR ePrivacy questions from the audience? Doesn't have to be a legal question. Up there, please. Do we have a microphone?
Shall I shout?
We can hear you. Yes.
Okay. I'm Alexander Kurtz from Newline. My question is related to storing information on mobile devices using things like iCloud or Google. What's the position in GDPR with relation to using iCloud, for example?
Well, I mean, it's very complicated. There are lots and lots of implications of storing data on iCloud.
Well, let's limit it to name, phone number, address, email.
Your 40-second answer to that now.
Well, so I mean, there are the implications of the provider of iCloud. That is obviously personal data. They have their own requirements as what we would call a data controller. If you're referring to what are the implications of consumers using it to store data, no, you're mainly concerned with businesses. So, I mean, it's the general principle that storing data is processing. So all of the requirements apply, data security applies, notice applies, in some situations consent might apply. So, you know, it's much like any other service, whether it's iCloud or email providers or general hosting.
Sacha, you mentioned, just to pick on the on-term service, you know, the online ad industry is awash with intermediaries. No, the entire value chain. As TV becomes more data-driven, be it on the advertising side, be it on the customer analytics side, they necessarily need to work more with third-party vendors. So how do all these third-party relationships that are in place now, coming into place now, as kind of Lego blocks in this whole ecosystem, how is that making stuff more complicated, and what do TV service providers need to watch out for?
Yeah, so that is probably one of the biggest issues in ad tech and data privacy, the complexity of the supply chain, and how do all those parties in the Lumascape that we're all sick of seeing at conferences, how do they all meet with the, all the various notice requirements? And the short answer is it's impossible, because the current regime and the future regime doesn't work under ad tech. Part of the difficulty is if you're, say, an SSP or a DSP or a DMP, and you don't have that direct consumer relationship, how do you meet all those notice and consent requirements? And that's actually what's informing the IAB's transparency and consent framework that they've been working on. And when you apply that to a connected TV environment, it becomes even more difficult because there's even less time to make privacy notices available. But I think probably what we're moving to is a place of preference centers and settings being much more interactive, and you're likely to see third-party providers either contractually or demanding that their own notices are made available through preference settings and things like that.
So it's certainly a big opportunity for lawyers, for, for you and your colleagues.
Yes.
Great. I think in the interest of time, a quick, yes, please.
Just on that point, in the directive, it talks about a controller, yet we're getting some responses back saying we're not a controller, we're a processor. Are you making, we're kind of not making a difference to that. Do you make a difference between a company saying we're just processing it, i.e. I hand it from him and I give it to him, so I'm out? Do you make a difference for that?
Yeah, absolutely. That comes up all the time. So historically, all of the different vendors that you might deal with would say, oh, we're just processors. And the reason why they would say that is under the current law, if you're just a processor, you're just a service provider, you don't have any direct liability. However, under the GDPR, processors will have some direct liability. So that caused all of the different ad tech vendors to start to think, well, actually, am I a processor or a controller? I don't even know. And they spent a lot of time thinking about it, and they thought, well, there might be some services or products where I'm a controller and some where I'm a processor. And that actually is very significant because it changes the terms and conditions that need to be in place. So the regulators generally think that ad tech vendors doing very sophisticated things are likely to be controllers, and that's mainly because historically that was the way the regulators could take action against them directly. But now there's less of a requirement to do that because processors will have direct obligations as well.
So I think it's going to be huge for many, as I think the deadline of implementation is in May, if I'm correct. And the last numbers I saw is that less than 50% of businesses are actually ready. But Sacha, thank you very much for your insights.